On a checked pink background is the Rising Flame logo on the top right. In the center is text in blue, My Rights, My Safety. Text in white in a red box says, a workshop series on people with disabilities and the law. On either side of the box are the scales of justice. Below this is the text, Workshop number 1, Protection of Children from Sexual Offences, POCSO Act. 9th June 2021, Dr. Aparna Chandra, Associate Professor at NLSIU.
Good evening, everyone. Welcome to this workshop series, My Rights, My Safety. On behalf of Rising Flame, I, Nidhi Goyal, the founder and executive director, would like to welcome all of you today. We're here together for 3 days, every evening from 5:30 to 7 p.m. India time, talking about law, accessing justice, what these rights look like for us. We know that women and persons with disabilities face violence, face numerous forms of violence, disproportionately higher levels of violence. Some studies say that women and persons with disabilities are 2 to 3 times more likely to face abuse and violence than their non disabled counterparts. But what happens to these forms of violence? What happens to this violence itself? Do we see it? No. This violence is often invisible, goes unreported, is hidden under the carpet, and worse, normalized. Now, why are we here today? To look at what this violence means, how is it a part of our lives, and what can we do about it? We really want to, we echo the sentiment that knowledge is power, and we want to know how to access this information around our rights. What does the law tell us? What are these legal frameworks which look difficult? Um, we're scared of them. We may not want to engage with them. We don't know that this is violence to even begin with. So, therefore, in these workshops, we will talk about what are these laws and what provisions they have, what are the protections they provide to us, but what are also the barriers that we could possibly face as people with disabilities, as women with disabilities, in accessing justice under these laws. We know that we're all in this middle of this very, very difficult time. In the pandemic time from last year, we've been talking about a shadow pandemic, violence, not just domestic violence, but sexual violence and others as well. This shadow pandemic has somehow touched many of our lives, but we're not talking about it enough. And definitely not talking about it in the context of disability, gender, child rights, and so on and so forth. How can we ensure our safety? How can we access our rights in this difficult moment, in this moment of disaster and pandemic across the globe? So, in this series, we look at various laws, Indian laws, and we will learn over these 3 days through the three laws around POCSO, that's around child sexual abuse and what those offenses look like, what are the protections that would happen today. Protection of Women from Domestic Violence Act, that would be training would be provided on that tomorrow. So there'll be a discussion on domestic violence and how justice can be accessed there. And the third day around sexual assault, so the criminal law amendments and what they look like. Today, to take the session and help us understand what POCSO means in layman terms, to decode the legal language, to understand what our rights are, but how to access them stepwise, how we can get rid of our fears, how we can build our own capacities, how we can move forward confidently and with full knowledge. We have Dr. Aparna Chandra, who's Associate Professor from NLSIU, Bangalore, where she also teaches constitutional law. Aparna's full bio will be pasted in the chat box for all of you who would like to access it. I would just like to, before handing over to Aparna, I would just like to take you through the flow of the workshop. After this round of introductions that I'm doing just now, Aparna will take a session for about 15 minutes to an hour, and then we will have the Q&A session. In Aparna's section, we are hoping to understand in simple words what the law tells us and what are the provisions for us, for children with disabilities. Who is the child with a disability who can be abused, who can be the abuser, what are the rights, how can children below 18 access this justice, how can families fight with them for their rights. This training will be in roughly 2 or 3 sections, and then we will have the last half an hour as a question and answer session, which will be facilitated by Rising Flames co-lead programs, Srimati Raghavan. Welcome once again to this 3 days series, My Rights, My Safety. Over to you, Dr. Aparna Chandra.
Thank you. Thank you, Nidhi. I hope my the audio is coming through clearly.
Yes, Aparna,
Right.
we can hear you
Thank
clearly.
you. Thank you, Nidhi, and thank you for giving me the opportunity to engage with all of you as part of this series. I have a lot to cover, so without much ado, I'm just going to jump into the presentation. Uh, so again, I'm sharing my screen. I hope the screen share is working. Please let me know if it is not. Uh, I have a very detailed PowerPoint presentation. Essentially, what I've done is I've looked at not just the provisions of the Act, but also of rules of model guidelines around the Protection of Children from Sexual Offences Act, and looked at some other, related laws. And so the PowerPoint presentations is very detailed. It may not be, I will take you through, give you an overview of each slide, and also discuss the slide before I move on from that slide, but it may not be possible for me to read out the slide in its entirety. The content of the slides will be shared with you in different formats. Rising Flame will take will take up that responsibility, I'm told. And if you have any questions that come up later beyond this session, please feel free to get in touch with me, and I would be happy to clarify. Okay, with that, we're going to be discussing the Protection of Children from Sexual Offences Act. That's the POCSO Act 2012. And if for those of you who might remember, there was a lot of discussion around this time about the need for a special law on child sexual abuse. And generally, this need was felt. This work on a special law for child sexual abuse was had been happening for some time. But generally, the issue was that it was felt that the general criminal law framework wasn't adequate to deal with child sexual abuse. One, and this is prior to the 2013 amendments. After the December 16 gang rape in Delhi, there were amendments to the general criminal law framework, but POCSO came before that. So at that moment, there was a very limited definition of sexual abuse in the general criminal law. You had penetrative sexual assault, which included only penile penetration. You had something called outraging the modesty of a woman, which dealt with every other type of sexual abuse. Punishments were thought to be very inadequate. These laws were not gender neutral. So till date, rape under the Indian Penal Code is not gender neutral. So that means that only a woman can be a victim, and only a man can be a perpetrator. So these are not gender neutral laws. And particularly for child sexual abuse, it was felt that there was need to cover boys who might be victims of sexual abuse as well within the framework of the laws. The only place where they actually found space in the general criminal law was in section 377 of the Indian Penal Code, which we know otherwise dealt with criminalized homosexual sexual behavior. But again, that locating all of child sexual abuse against people who are not women in section 377 was problematic for various reasons, including the fact that the law talks about that section talks about carnal intercourse against the order of nature, and that's a very broad, vague kind of term. So it's not very clear what exactly it means. So just in terms of definitions and punishments, the general law was thought to be inadequate. Then even in terms of procedure, the general criminal law treats adults and children alike. It has been enacted keeping adults in mind. It's a system by adults for adults, and children were not really in you know were not the really the target uh, audience of those laws. So the procedural laws, the systems that the laws set up, did not take into account the unique and specific needs of children, the distinct needs of children who might be who have been sexually abused, and who might need child-friendly procedures for reporting, for taking of evidence, for investigation and trial of offences. So it's for these reasons that need was felt for a special law on child sexual abuse. And so this will explain why what POCSO then ends up doing is that it's a comprehensive legislation. So it's a broad law, it's a comprehensive legislation that not only defines sexual abuse, or various offenses which constitute sexual offenses under this law, but also provides details of the procedures that have to be that have to be followed in investigating offenses, in trying these offenses, and providing other range of services to the child. So the statement of objects and reasons, which is a document that's generally appended to a bill and tells us what it is that Parliament was thinking when it enacted that law. It says that they consider POCSO to be a self-contained comprehensive legislation to provide for protection of children from the offences of sexual assault, sexual harassment, and pornography, with due regard for safeguarding the interest and well-being of the child at every stage of the judicial process, incorporating child-friendly procedures for reporting, recording of evidence, investigation, and trial of offences, and provisions for establishment of special courts for speedy trial of such offences. And very importantly, one of the key characteristics of this law is that it it considers child sexual abuse to not only be a law and order problem that requires a police intervention and requires a court intervention, but it envisages this child sexual abuse as requiring what it calls a multi-sectoral intervention, which involves the police, which involves the court, but also involves a range of other support services, including medical support services, legal support services, other kind of health and well-being support services. And we'll see how these services come into play and how they interact. Okay, just in terms of who is a child for purposes of this law is 18 sexual activity, which is other than sexual intercourse. Any sexual activity with a person under the age of 18 is an offense under this law, regardless of the consent of that person. So the age of sexual consent in India gender neutral, which means that a victim could be any person, that is a male child, a female child, anywhere on the spectrum. So it's not gender specific as the general law. And there is no age proximity clause. What do I mean by age proximity clause? In many other countries, there's a recognition that people under the age of 18 who might otherwise be vulnerable to sexual abuse are also at a stage in their life when they engage in a lot of sexual experimentation with their peers. And you don't want to criminalize that kind of sexual experimentation, or sexual, don't no need to call it experimentation, that's sexual expression under the all sexual expression under the age of 18, in a situation where it is not abusive, it's not exploitative. In that situation, many countries provide for age proximity clauses, and they say that if it's a person under the age of, whatever is the age of sexual consent in that country, but if a person is, say, under the age of 18 but engages in sexual activity with a person who is say in 2 or 3 years removed from this person, then you will not count that as necessarily a sexual offense, or you will not treat it as harshly as you would if, for example, a person who is 15 years of age engages in sexual activity with someone who is 25 or 30 years old. But in India, there's no age proximity clause. So that means that if you have two people under the age of 18, if you have two people under the age of 18 who engage in sexual activity, and again, sexual activity is broader than sexual intercourse, but who engage in sexual activity, then both of them would technically be committing an offense under this act. How that plays out, we'll see. But that's the general overview of how the law approaches the question of consent. Yeah. Okay. So the first offense that this law provides is what it calls penetrative sexual assault. Now, if you remember, I said that under the Indian Penal Code, before the 2013 amendments, the only kind of penetrative sexual assault that that law recognized was the penetration, penile penetration, and no other form of penetration. But here, what the law does is it first defines penetrative sexual assault, but includes penile penetration as well as object penetration and other forms of penetration, right? So any type of penetration into the orifices of the child, any type of penile penetration into any orifice of the child, or any kind of object penetration or digital penetration into the vagina, urethra, or anus of the child is then is considered to be penetrative sexual assault. And again, application of the of a person's mouth to the penis, vagina, anus, urethra of the child would also amount to penetrative sexual assault. Punishment for penetrative sexual assault is a minimum of 10 years, a minimum of 10 years, but can also extend to life imprisonment. That's the general rule. But if the child who's been sexually assaulted is under the age of 16, then the minimum punishment is 20 years, and that can extend to imprisonment for life. And imprisonment for life here means rest of the natural life of that person, right? So keep this in mind in the context of the fact also that there's no age proximity clause. There is no question of consent in any of these rules. So right now, then the law, for penetrative sexual assault, the minimum punishment is 10 years. If the child is below 16, the minimum punishment is 20 years. There's also possibility of fine. The fine itself should be enough so that the victim's medical and rehabilitation expenses can be met. So that's the fine is not quantified. It just says it should be just and reasonable, should be paid to the victim to meet the medical expenses and rehabilitation of such victim. Now, on top of penetrative sexual assault is aggravated penetrative sexual assault. What do you mean by aggravated penetrative sexual assault? When the sexual assault is committed by certain persons who are in authority, such as police personnel, armed force personnel, public servants, people who are on the management of staff of certain institutions where they have the care of children, where family members, persons in authorities, etc. Such, when penetrative sexual assault is committed by such persons, or where it is committed against certain victims, for example, where it is committed against a child who is who has mental or physical disability, or a child who is below the age of 12. Keep this in mind. This is very important in the context in which we are discussing, that if a penetrative sexual assault is committed against persons who have mental or physical disability. So it says taking advantage of a child's mental or physical disability, or for children below the age of 12, or there are certain other criteria. then this amounts to aggravated penetrative sexual assault. Or when penetrative sexual assault is committed under certain circumstances, such as using deadly weapons in the course of violence, like communal violence, or in the course of natural calamities or certain other situations. In these situations, if penetrative sexual assault is committed, that is called aggravated penetrative sexual assault. And when there is aggravated penetrative sexual assault, then the minimum punishment is 20 years and the maximum punishment is death. So this is after amendments in 2019. So for aggravated penetrative sexual assault, which includes assault taking advantage, penetrative sexual assault taking advantage of a child's mental or physical disability, when there is such an aggravated penetrative sexual assault, the maximum punishment is death. This the one consequence of having such high punishments is that, as many of you will know, much of sexual assault that happens generally happens between either within families or within acquaintances. A lot of child sexual abuse, a large percentage, predominant percentage of child sexual abuse also happens either within families or within acquaintances. In such situations, when the punishment is so high and so harsh, there is a fear that many child rights activists have that that there will be a chilling effect on reporting of such offenses, because people don't want to necessarily put someone to death, or put away someone who might, for example, be the earning member of the family into prison for 20 odd years. But that has been the trend and the trajectory in this law, that the law has been amended even between 2012 and 2019. It has been amended multiple times to increase the punishment. And right now, for aggravated penetrative sexual assault, the punishment is maximum of death. Then there is sexual assault, which is basically non-penetrative sexual assault, which, again, if you remember, in the Indian Penal Code, there's just this one section on outraging the modesty of a woman, and that covers the entirety of non-penetrative sexual assault. In under POCSO, there is a separate definition of sexual assault, which is basically non-penetrative sexual assault. And similarly, if it is committed in under the same conditions as aggravated penetrative sexual assault, if it is done under those circumstances, then it would amount to aggravated sexual assault. And again, the punishment for this is a minimum of 3 years, maximum of 5 years for sexual assault, minimum of 5 years and maximum of 7 years for aggravated sexual assault. There is also a definition of sexual harassment. And sorry, before I get to sexual harassment, remember, this is why when we are talking about POCSO, we are no longer talking about sexual intercourse, but we are talking about sexual activity, because even activities that do not amount to intercourse, sexual activities that do not amount to intercourse would be covered under POCSO. Again, there's a definition of sexual harassment, which is very much in line with the Sexual Harassment Act and then the 2013 amendments. And for sexual harassment, there has to be a person is said to commit sexual harassment upon a child when the person with sexual intent utters words, makes gestures, etc., etc. And again, you can look at I will pass on this PPT so you can have the definition with you. But so where there is a activity with sexual intent, that activity which does not fall into which does not amount to sexual assault would amount to sexual harassment. And punishment for sexual harassment is a maximum of 3 years and with fine. And then finally, there is the offense. The final offense under this law is the use of a child for pornographic purposes. So what do we mean by using a child for pornographic purposes? Again, it's a very wide definition, and it says that whoever uses a child in any form of media uh, for the purposes of sexual gratification, which includes representation of the sexual organs of a child, usage of a child engaged in real or simulated sexual acts, indecent or obscene representation of a child, shall be guilty of the offense of using a child for pornographic purposes. And again, there is a punishment for that. Very importantly, there storage of pornographic material involving a child for commercial purposes. So even possession of child pornography for commercial purposes is an offense under this law. Right. So these are the broadly the four offenses: uh, penetrative sexual assault, non-penetrative sexual assault, sexual harassment, and pornography, child pornography related provisions. Now, one thing that, because these offenses are so broadly defined, there could be a range of activities that might otherwise, that might require, for example, a caregiver to say touch the private parts of a child, or a medical a doctor to touch the private parts of a child. And in those cases, this issue of whether the activity becomes an offense or not was was a concern. And so the law provides under section 41, it says that these offenses shall not apply in cases of medical examination or medical treatment of a child, when such medical examination or medical treatment is undertaken with the consent of his parents or guardian. So basically, if there is otherwise the ingredients of the offenses are met, but that is in the case of medical examination, or in the context of medical examination or medical treatment of a child, when the consent of the parents or guardian had been taken, then that will not amount to an offense. There's a concern that child rights activists have that this exception itself is very broadly worded, because medical examination is one thing, medical treatment of a child is a much broader term. And just because you've consented to the medical treatment of a child does not mean that the doctor can, and or the whoever is providing that medical treatment can do whatever or can have such a blanket exemption from the provisions of this law. So there have been calls for taking a relook at this provision. So that's, but as it currently stands, there is this exception. Now, another thing that this law does, remember, one of the concerns with child sexual abuse is that, one, it is very rarely reported, but second, when it is reported, it's very difficult to prove. And what this law does is, therefore, it says that if someone is prosecuted for committing an offense under this law, then the court will presume that the person has committed this law, unless the accused can prove that they did not commit the law. So typically, if you know, as I'm sure you'll know, that we operate with a presumption of innocence. And we say that, if the state wants to prosecute me for something, we will start with the presumption of innocent. And the burden is on the state to prove beyond reasonable doubt that I have actually committed that offense. If the state can't prove it, then I go scot-free. Here, there is a reversal of that burden. And what this law says is that, it says that if you're being prosecuted for an offense under this law, we will presume that you've actually committed that offense, unless you, the accused, can prove that you haven't committed that offense. Now, there's a lot of criticism of this kind of reverse, what are called reverse burden clauses, generally. Under many human rights, instruments, or many human rights courts have said across the world that these don't meet human rights standards. In the Indian context, but in the context of POCSO, it's particularly troubling, because you have penalty up to death for offenses for which this presumption applies. Second, you remember, for example, in things like sexual harassment, the act had to be with sexual intent, right? That someone who does a particular act with sexual intent. Now, the law here also says that if someone, if you have to determine, you will assume, the law will assume that that any intent that is, or knowledge that is required to be proved actually exists. So you will presume that sexual intent exists, and it is accused has to prove that actually it did not exist. So if you have to show that that sexual that this was with sexual intent, it is not on the state to show that this was actually with sexual intent. It is for the accused to show that it was not with sexual intent. It's roughly the same thing. You've shifted the burden on the accused. You will assume that the accused actually committed the crime, and committed the crime for the reasons, or for reason of sexual gratification, for example, um, rather than and the accused has to show that no, they didn't actually do it. So that's been a very controversial provision of the POCSO law. But this is the offense that these are the offenses that the law has. These are the punishments that the law has. How does the law get activated? What the law does is that it has what's called a mandatory reporting requirement. What is a mandatory reporting? It's a universal mandatory reporting requirement. Section 19 of the Act says that any person, including in fact the child who has been sexually abused, any person who either has an apprehension that an offense under the Act is likely to be committed, so it's not been committed, but you think that an offense under the Act is likely to be committed, or has knowledge that such an offense has been committed. So either you think that an offense might be committed, or you know that an offense has been committed, you have to provide such information to the police, or if there is this special juvenile police unit, then to that unit, but otherwise to the police, right? So there is any person, and there's no qualifications to this. So any person who thinks that an offense under the Act might be committed, or knows that an offense under the Act has been committed, has to inform the police. Now, this kind of a mandatory reporting requirement is there again because child sexual abuse is very often is underreported. Many people might generally be in the know about child sexual abuse, but might not report it to the police, and that as a result, children might continue to live in unsafe situations. But of course, the flip side of this is that it creates a burden on when a child reaches out for help to for example their teachers, or seeks medical intervention. There's an obligation on now the teachers, the doctor, anyone that they reach out to actually report this to the police. And if they don't report it to the police, they will suffer imprisonment up to 6 months or fine. So as a result, we are seeing this, I'm seeing this in much of my work in the area of reproductive and sexual health services, where we're seeing that there's a whole chilling effect on doctors unwilling to provide sexual and reproductive health services to minors, because any activity under the age, any sexual activity under the age of 18 is of course an offense under this Act. And so if a minor goes to a doctor, for example seeking an abortion, or even seeking contraception, goes to a doctor with STDs under the age of 18, the doctor has an obligation to report the person to the police, regardless of whether the person wants to or not. So there is no option that the person does not, the child or the child's guardian parent do not have an option to opt out of the criminal justice process. So that is again a very controversial provision in POCSO, but there is this kind of a mandatory reporting requirement, something that those of us who work with children should definitely know about, because this is an obligation on everyone. There's no exception to this. So what happens? So you've reported to the police. Now what happens? So once the report is filed with the police has to enter this record the report in writing, give a copy of that report to the informant, read over the report to the informant, make sure that you've got the right report, and then that triggers the process, right? So in making sure in taking down this report in writing, the content should be recorded in the, as far as possible, in the language that the child or the person who's making the information can understand. And where a translator or an interpreter is required, then such a translator or interpreter should be provided. So So that's the general broad step that the police has to take immediately. And then that triggers a range of actions that the police then subsequently have to take. So they have to take three distinct actions. First is to provide emergency medical assistance to this to the victim. um, that's one thing. The second thing is to initiate investigation and trial, so initiate the legal process. And third is to initiate the care and protection of this child, so a process for ensuring the care and protection of this child. And what I'm going to do now is just briefly take you through each of these three processes to say, once a report is filed, what happens on the medical front, what happens on the judicial front, and what happens on the care and protection front. So, okay, before that, here are the things that a child who has suffered sexual abuse is entitled to from the police. These are this is a form that's there in the POCSO rules, and the station house officer has to certify that each of these things has been provided to the child. So they'll get this form. They'll tick this form and give a copy to the child or to their parent or guardian. And so one should keep in mind that these are entitlements that the child has. And and if at I mean, if these things have not been provided, then that's a point to take up both with the police at that moment, but subsequently with other support services, and we'll come to what those other support services are. But the entitlements include to receive a copy of the FIR, to receive adequate security and protection by the police, to receive immediate and free medical examination, to receive counseling and consultation for mental and psychological well-being, for recording of statement of child by a woman police officer at the child's home or any other place convenient to the child, to be moved to a child care institution if the offense was at home or in a shared household, so if it was within the family, to the custody of a person whom the child reposes faith in, to immediate aid and assistance on the recommendation of the child welfare committee, and I'll come to that, uh, to be kept away from the accused at all times during trial and otherwise, to have an interpreter, have a translator where needed, to have a special educator for a child or other specialized person where the child is disabled, for free legal aid, for support persons, for continuity in education. So while making a child, the care plan for a child, you have to ensure that their education does not get disrupted, to privacy and confidentiality, and for a list of important contact numbers. So these are the entitlements that children have to information and to services, and the police has to provide this and has to certify this, and that has to be countersigned by the child's parent or guardian. So that's something to keep in mind. But for emergency medical aid, the police has to arrange that emergency medical assistance within 24 hours. In that medical care will be provided in the presence of a parent or guardian, and a medical practitioner or a hospital cannot turn away a child or demand any legal process or any magisterial requisition, etc., before rendering such care. And the therapeutic care that has to be provided includes not just physical injuries, but also sexual and reproductive health services, as well as mental or psychological health needs that the child might have. So that all of these health services have to be, or health needs of the child have to be provided. So that's about immediate emergency medical aid. The second thing that the reporting triggers is investigation and trial. So the police will register an FIR and furnish a free copy to the person who's informed the police. The police will then, of course, take the child to the hospital, both for emergency medical care, but also medical examination. Again, I'll come to medical examination in a bit. The samples that might be collected from the child, including their clothing, for example, or swabs, etc., will be sent for forensic tests to the forensic laboratory. And the child is entitled to under the law, under POCSO, the child is entitled to their own legal aid and legal advice, and it is the duty of the police to inform the child and their parent or guardian of the right of the child to these legal aid, legal advice, etc., and how to secure it. So that's something that the police has to do immediately in terms of setting in motion the criminal justice process, the legal process. So first thing that happens after an offense is recorded is, and your medical examination will take place, but the first thing that happens is the victim's statement is recorded. And the victim's statement can be recorded in two stages. One is it can be recorded by the police, and second, it can be also be recorded by the magistrate. Now, in recording the statement by the police, that's the first statement taking that happens. It's a statement that's taken by the police. That statement of the child will be recorded either at the residence of the child, or at a place where the child usually resides, or a place of the child's choice, right? So the convenience of the child is of paramount importance, as per the law, at least. This is of paramount importance, and as far as practicable, by a woman police officer, not below the rank of the inspector. Again, to make it child friendly, the police officer should not be in a uniform. The police officer should ensure that the child does not come in contact with the accused. The child cannot be detained in the police station at night for any reason. And the police officer has an obligation to ensure that the identity of the child is protected from the media, unless the court directs otherwise. So those are the conditions under which the statement of the child will be recorded. I'll come to a recording of statement by the magistrate, and then come to special, how to meet any distinctive needs that a child with disabilities might have. So this is a recording of statement by the police will take a statement. The police might want to go to a magistrate and get the child's statement recorded by the magistrate. Why this is very important is because, and you'll do this in your session on the Criminal Law Amendment Act, but what the Criminal Law Amendment Act says is that if you get your statement recorded by a magistrate at this moment, that you will not have to come back to court and give your statement all over again as a child or as a person with disability. You won't have to come back and give your statement all over again. You can directly come only for cross-examination. So you don't have to come and say everything all over again. You will come, and the other party will ask you questions based on the statement that you've made. So you might want to go and get the statement recorded by the magistrate. And this is happening. You don't wait for the trial process to start, and it might start months to years down the line. You might want to get the statement of the child recorded immediately. So so the child statement can be recorded immediately, and the copy of that statement shall be provided to the child, etc. But there are important protections that are given to children generally, and to children with the disabilities in particular, in the recording of the statement, both by the police officer and by the magistrate. One is that the statement will be recorded in the presence of the parents or guardian, or any other person with the child has trust and confidence in. Where required, an interpreter, translator, etc. will be provided. If the child has mental or physical disabilities, then the court will seek the assistance of a special educator or any person familiar with the manner of communication of the child. This is very important, and I'll come to it again. Any person familiar with the manner of communication of the child, or an expert in that field having such qualifications, so on and so forth. And where possible, the magistrate shall ensure that the statement of the child is recorded by audio visual electronic means. This is under POCSO, under the Criminal Procedure Code, the General Criminal Procedure Code, after the 2013 amendments. If it is a child with disability, then this mandatory for this statement to be videographed. And why is that? It is so that if there are if there's any non-verbal communication that is taking place, the child is communicating in ways that are non-verbal, that should also be recorded. So that's why videographing for persons with disabilities is provided for mandatorily in under the Code of Criminal Procedure, and that would apply here as well if it's a child with disabilities. Now, who's a person familiar with the manner of communication of the child? It means either a parent or a family member of a child, a member of the child's shared household, etc., etc., who is familiar with that child's unique manner of communication. Now, this is very important again, because it's not just any sort of external, as we all know, um, uh, different children generally, but also specifically children with disabilities might have their own, unique way of communicating, and a person who is involved in the caregiving of that child is likely to know best how that child is communicating. So that person can act as the intermediary between the child and the magistrate or the police officer. If there's need for additional interpreters, translators, special educators, etc., each district has to maintain a register of such of persons with such names, details, etc., and that should be available with the local police, with the magistrate, with the special court, etc. Again, this is unfortunate, this is there in the law, unfortunately not particularly followed in practice, but that is something that that is provided for. I should say, in terms of victim statements and other processes that get triggered, it's very important when reporting an offense to definitely report that the person is, one, under the age of 18, and second, if that person has mental or physical disabilities. As we noted early on, if this is a person who has if the sexual assault happens on a person who has mental or physical disabilities, then that counts as aggravated assault, and there's a different process that might take place. Second, if this person is, one, it's a child, then the entirety of POCSO comes into play. But second, if it's a person with disability, then many of these specific rules and regulations and come into play. So recording that this is a child with disabilities is very important in that initial stage. And for someone who is accompanying a child for recording of information, should make sure to have that point included in the report. Okay. So the statement of the child is taken, the child is sent for medical examination. For a girl child, the examination is conducted by a woman doctor. Again, medical examination should be either in the presence of the parent or another person in whom the child reposes trust or confidence, or in the absence of any such person, by the by a by someone nominated by the head of that institution. The consent of the child to the medical examination is required. If the child is under the age of 12, then the consent of parents is sufficient. Above the age of 12, the consent of the child is also required. There's a general provision in the rules which says that if the child is a person with disabilities, suitable measures and care shall be taken as per the provisions of Persons with Disabilities Act. So any relevant rule under the Right of Persons with Disabilities Act which deals with medical examination will be applied for a child with disabilities. Um, and then, of course, this medical examination will also be, the report will be submitted to the local police, and forensic evidence will also be passed on to them. Then comes so that's the investigation process. Then comes the trial process. Now, what POCSO does is it creates special courts for trial of offenses under this law, and creates a cadre of special public prosecutors. The idea is that these judges and these public prosecutors can be trained in providing a child-friendly judicial process. And that's why special courts and special public prosecutors have been provided for under this law. Many places where special public prosecutors have not been appointed, and that causes its own range of delay in the conduct of cases, and that creates its own bottlenecks. But the idea was to have special courts and special public prosecutors, so that you can have the conduct of the entire process in a child friendly manner. Now, in the trial process, the lawyers do not communicate directly with the child. The questions will be put to the to the court, and the court will in turn put the questions to the child in a manner that is again child friendly. The if the child needs it, the court will provide for frequent breaks. The court has a general responsibility to create a child friendly atmosphere, allow a family member, guardian, someone the child has confidence in it, to be present in court. The requirement at least is that the child shall not be called repeatedly to testify in court. Unfortunately, in practice, that doesn't always, it doesn't translate in practice. The special court will not permit aggressive questioning, character assassination, so on and so forth. And the identity of the child shall not be disclosed. The trial process itself happens in camera. In camera meaning it happens, the outside public is not allowed. It's only the parties, the child's support person, etc., who are allowed into the into the courtroom when the trial is taking place. And the child's identity cannot be disclosed unless the court believes that such kind of a public disclosure is in the interest of the child. Otherwise, the identity of the child cannot be disclosed, and that includes identity of the child's family, school, relatives, neighborhood, etc., other information through which the child can be identified. Now, the law says, again, this is observed more in breach than in practice, but that the evidence of the child should be recorded within the period of 30 days from when the special court takes up the matter, and the special court should try as far as possible to complete the entire trial within 1 year. Again, both of which, like I said, don't really happen in practice. But the special court has to ensure that the child is not exposed to the accused at any time during the recording of evidence. And different states have created different kind of mechanisms. In Delhi, for example, there are these vulnerable witness deposition complexes that have been created, where fairly sophisticated sort of mechanisms have been put in place to ensure that the child and the accused don't come in contact with each other, where the child does not come in contact with the accused, but the accused has full view of the entire trial process, and so the accused rights are also met. Like I said, trials have to be conducted in camera, and again, the assistance of an interpreter or expert while recording the evidence of the child where needed is to be provided, and that includes any person familiar with the manner of communication of the child, in case it's a child with disability. Okay, so this is the trial process. Then the third element that gets triggered is the care and protection framework. Now, like I said, the initial report is to the police. So now the police has the initial responsibility to trigger care and protection. One, the police has to inform the child and the child's guardian of the availability of support services, and we went through that form of the kind of support services that have to be provided. I'm going to take about 5 minutes more, and then I'll finish. If it is a person, if it is a child who might need care and protection in terms of the Juvenile Justice Act, which is in 3 situations. If the police believes that the child has been abused by a person who's living in the same or a shared household with that child, or the child is living in a childcare institution and is without parental support, or the child is without any home and parental support, in such situations, the police has to take the child to the Child Welfare Committee within 24 hours, as soon as possible, but within 24 hours. So you will take the child then to the Child Welfare Committee, and the Child Welfare Committee will then decide how to provide for the care and protection of that child, including whether the custody of that child has to be given to some other person or some other institution, so as to protect the child from ongoing abuse. And there are a range of factors that the CWC looks at. The Child Welfare Committee, it's a body under the Juvenile Justice Act, looks at in making this determination. But every case, every case of child sexual abuse, the child will not be produced before the CWC. It's only when there is a fear that the child is not safe in their current situation, is when the police will produce the child before the child welfare um, committee. But regardless, the police has to inform the child welfare committee whenever a case under POCSO is registered. And in that situation, the CWC may provide a support person to render assistance to the child. Now, this support person is is someone who will handhold the child and their parents through the entire process. Again, there lots of details on the slide itself, or what are the services that the support person will provide. But broadly, the support person will help the child and the parents or guardians navigate the judicial process. Will let them know about the services that are available, the assistance that is available, what are the judicial procedures that are possible, uh, and prepare the child for their interaction in court, etc. The support person is also required to keep the CWC informed about the completion of the trial and the ongoing care of the child. Um, okay. Uh, then the other care and protection element that comes in is that the child has a right to legal aid and assistance. Sorry, the support services also includes other kinds of support services that the CWC might feel that the support person along with the CWC can determine that this child needs psychological counseling, this child needs additional help, support, etc. And the support person in consultation with the CWC can facilitate the provisioning of these services. So going back to that multi-sectoral approach. The support person then becomes the key point of contact who will ensure that all these services and facilities are provided. Finally, like I said, the child is entitled to legal assistance. And again, that's something that the CWC, as well as the police, the CWC, as well as the support person, are all obligated to secure for the child. The District Legal Services Authority is the authority which provides these services. Now, finally, on relief and compensation. Now, if the child is in need of specific relief immediately, does not have, for example, access to food, clothes, transport, etc., then the CWC might recommend that an amount should be provided to the child or to the child's caregiver for these purposes. And that amount has to be provided within a week of the recommendation being made. The child is also entitled to compensation from the state. So one is specific relief to meet immediate needs. Second is compensation, final compensation. So most states have victim compensation funds, and those funds cover a range of offenses. But for child sexual offenses, most states have certain amounts set aside, and it is the District Legal Services Authority that generally disperses those amounts. And for the court has to then recommend to the District Services Authority, either on its own accord or on an application being filed. So if one is a support person to such a child or a caregiver for such a child, one should look for should file an application. If the court is not acting on their own, file an application for interim compensation, and the court will make a recommendation for interim compensation as well as final compensation. The compensation entitled from the state does not depend on a finding of guilt, or guilt of the accused. There might be a range of reasons why a person is not found guilty under the law, that does not necessarily mean that the child has not been sexually abused. So therefore, just to keep that in mind, keep in mind that the child that the compensation from the state is not dependent on a finding of guilt. The state government has to make the compensation payment within 30 days of receipt of such an order. Again, in practice it doesn't really happen, but that's what the law says. And thirdly, remember, there's a fine component in the punishment under this law. That fine has to also go to the victim. That's only on the finding of guilt. Once the accused is found guilty, the CWC shall coordinate with the district legal services authority to make sure that any amount that the special court has imposed as a fine, it actually reaches the victim. So this is the law functions. These are the rights under the law. These are the procedures under the law. Like I stressed, because this is a know your rights event, I've focused mostly on what the rights are, and I've tried to show you where one can make sure that how one can make sure that the rights are availed of. Unfortunately, while much of the law, particularly its procedural aspects, looks very good on paper, it doesn't translate into practice because of both, lack of training, lack of adequate staffing, so on and so forth. But the rights are there. Knowledge, as long as it's coupled with knowledge, both on part of people who are using the law as well as people who are authorities under the law, we hopefully the law can be realized in practice, the rights can be realized in practice as well. But this is what the law says, and I've taken this from the act itself. I've taken this from these provisions from the rules under the act. The 2020 POCSO rules were amended in 2020, and so those rules, there are model guidelines that the Ministry of Women and Child Development has issued under this law. Guidelines under this law have to be issued by states, but what the central government has done is it has issued model guidelines for states to follow, if the states so wish. But these are model guidelines, and those guidelines are available, and they have very high persuasive value. So if you're asking for an authority to do something, pointing to the model guidelines is always a good thing. So I've looked at those model guidelines, and then there are model guidelines again issued by this Ministry of Health and Family Welfare on medical examination of persons who have been sexually abused, and I've looked at those guidelines as well. What I will do is I will pass on those documents to Nidhi and her team, and perhaps that that can also be placed somewhere accessible in an accessible manner, so that for those who are interested in looking at the actual laws themselves, they have those resources available. Okay, with this I will I will stop here, and happy to take questions.
Thank you so much for all the details and for going into the law with so much detail. What I think we have one question in the chat box already, and then we can rotate, and then we can open the floor and ask if anybody has any questions. So in the chat box, the question that is there is how much is POCSO implemented on the ground in case of disabled children?
The POCSO, unfortunately, the implementation of POCSO is incredibly patchy. It depends state to state. There is a report, a Human Rights Watch report, which, if I'm not mistaken, Rising Flame also collaborated on, which looks at the implementation of POCSO on the ground in 7 states, if I'm not mistaken, and finds that the record is very patchy. There is an ongoing case in the Supreme Court where the Supreme Court has been, monitoring the implementation of these services, and essentially it means every 6 months or so the Supreme Court pulls up the various state governments for not doing what they're supposed to do, and then the matter slides into oblivion. So as such, where additional support services are required, the experience has been very patchy. But to the extent that the power is with the court itself, right, where the court can allow, for example, a person who's familiar with the child's communication patterns to assist the child in giving in to act as an intermediary in narrating the incident, those things happen. Those things, there's a better record of those provisions being implemented. But to the extent that additional services have to be provided by the state, unfortunately the record is incredibly patchy.
Is just as a follow-up question, this is primarily because of the system not having access to interpreters, etc. Is it?
So two things, yes. One is every district, actually the district child protection unit is supposed to maintain a list of interpreters and maintain a list of experts, interpreters, etc. For that district, and that's supposed to be available to all the authorities,
Yeah.
including the local police. The problem is, I think, a very basic problem is that there isn't enough of an understanding also of what the various distinctive needs of say persons with disabilities are, right? So you might have one interpreter who can interpret, say, who knows sign language, but that is not the interpretation skill that you require for that particular child with disability. So there is often this kind of a mismatch in where the failure happens. So on paper you might tick off the boxes, but in practice there's a failure that happens, a state failure that happens on the ground, because there's a mismatch. That's also just a fundamental question of not understanding what you're actually required to be doing in order to give effect to the law.
Yeah. I think that's a pertinent example of not understanding enough about the needs of the disabled child as well. And but I think that also feeds into the reporting for the disabled child, I suppose.
Yeah.
So that itself is step one in the process. If anybody else has any questions, it would be you could either type it in the chat box or you could unmute yourself.
सो अभी जस्ट मैंने अपना फील्ड वर्क ख़त्म किया है एम फिल का, और मेरा जो काम है वो मुकबधिर महिलाओं के साथ यौन हिंसा को लेकर है। अगर उनके साथ यौन हिंसा होता है तो फिर वो जस्टिस तक कैसे एक्सेस कर रहे हैं, क्या चैलेंजेस हैं, उसको लेकर मेरा काम है। और अभी जितने भी मेरे पास 7 से 8 केसेस हैं जो विमेन विद हियरिंग एंड स्पीच डिसेबिलिटी को लेकर हैं। और मैम सारे केसेस में मैंने एक चीज़ जो कॉमनली पाई वो ये है कि जो साइन लैंग्वेज इंटरप्रेटर्स हैं वो किसी भी जगह पे नहीं मिल रहे हैं। उनकी जगह पे जो लोग उन्हें प्रोवाइड कराए जा रहे हैं वो हैं स्पेशल एजुकेटर्स। और स्पेशल एजुकेटर्स मैम उनकी साइन लैंग्वेज, क्योंकि वो बता तो पा रहे हैं, क्योंकि उनको जब वो बीएड वगैरह कर रहे थे तो उनको एक पेपर के रूप में पढ़ाया जाता था साइन लैंग्वेज, लेकिन वो उस तरह के साइन नहीं कर पा रहे हैं जिस तरह के साइन वो कर रही है, लड़की कर रही है, जो महिला कर रही है। क्योंकि मैम आप जानती होंगी साइन लैंग्वेज के बारे में कि साइन लैंग्वेज एक तो वो है जो बाहर बच्चे निकल रहे हैं जिनका दूसरे लोगों के साथ उठना बैठना है तो उनका एक अलग साइन है, लेकिन एक वो घरेलू साइन भी करती है। सो घरेलू साइन वो लोग नहीं बता पा रहे हैं, और एक तो ये दिक्कत है। दूसरा ये है कि जो राइट्स उनको मिले हुए हैं, पर्सन विद डिसेबिलिटी के जो राइट्स हैं उनको लेकर उनके साथ किसी भी तरह का वर्कशॉप नहीं होता है कि वो उनके राइट्स कितने इम्पोर्टेंट हैं वो समझें। कई सारी जगहों पे मैम कई सारे केसेस ऐसे हैं जो पर्सन विद डिसेबिलिटी कुछ साइन कर रहा है, उन्होंने कुछ बताया है कोर्ट में, और वो केसेस ख़त्म हो गए बहुत बुरी तरह, और ख़त्म नहीं हुए तो बहुत बुरी तरह से डैमेज हुए। सो एक चीज़ तो ये है कि इम्प्लीमेंटेशन होगा, लेकिन जो प्रोसेस में जो शामिल लोग हैं वो कितने सेंसिटिव हैं इसको लेकर मुझे लगता है कि बातचीत होनी चाहिए। और दूसरा मैम ये है कि जो स्पेशल एजुकेटर्स हैं जो रखे जा रहे हैं स्कूल्स में, जो डिस्ट्रिक्ट्स के स्कूल हैं वहाँ पे पर्सन विद डिसेबिलिटी जो बच्चे हैं उन बच्चों को पढ़ाने के लिए, मैम उनको उनको पे करने वाला जो पूरा जो प्रक्रिया प्रोसेस है वो बहुत कम है। उनको जो मिलता है पेमेंट, जो वेतन मिलता है वो बहुत कम है। उसकी वजह से वो लोग आसानी से उस सबके उसमें आ जाते हैं। सो एक चीज़ तो ये है मैम, मैं जानना ये चाहता हूँ आपसे कि मैं ये दिख रहा था कि इनको लेकर सपोर्ट सिस्टम क्या है, सपोर्ट मैकेनिज्म कैसे काम करता है। अपने मेरा रिसर्च इसको लेकर है। इसके बाद मैं जब अगली बार जब इसका पीएचडी का काम करूँगा एमफिल के बाद, तो फिर मैं इसको एक्सटेंड करूँगा। मैं ये जानना चाहता हूँ कि क्या पॉक्सो या कोई और कोई ऐसा कानून है या जिसमें ये प्रोविज़न है जहाँ पे कि अगर साइन लैंग्वेज इंटरप्रिटेटर अगर ठीक से अपना काम नहीं कर रहे हैं, या स्पेशल एजुकेटर्स अगर वो वायस हो रहे हैं, तो क्या उनके ऊपर कोई कमेटी है क्या?
अम, तो आपने बहुत सारी बहुत अच्छी बात बहुत पर्टिनेंट बातें रखी हैं। तो मैं बस कुछ कहना चाहती हूँ उसके बारे में, फिर आपके क्वेश्चन का जवाब दूंगी। पहला तो ये पॉइंट आपने ठीक कहा कि इंटरप्रेटर्स नहीं रहते, तो स्पेशल एजुकेटर्स को ले आते हैं। स्पेशल पर्टिकुलरली साइन लैंग्वेज, अगेन साइन लैंग्वेज इंटरप्रेटर्स नहीं हो तो स्पेशल एजुकेटर्स को ले आते हैं। उन सिचुएशंस में बस ये एक जानने वाली बात है कि कानून एटलीस्ट पॉक्सो कहता है कि आप घर के किसी व्यक्ति को भी ला सकते हैं। और ये बहुत लोग ये जानते नहीं हैं। कोर्ट सिस्टम में कानून में लिखा हुआ है, कोर्ट सिस्टम में लोग नहीं जानते हैं। उनको लगता है कि अगर माँ बाप को लेते हैं तो माँ बाप अपने वो जो बोलना चाहे वो खुद बोल देंगे, वो इंटरेस्टेड पार्टी हैं, तो इसलिए किसी को बाहर से लाना चाहिए। लेकिन कानून में ये लिखा हुआ है कि आप घर के किसी आदमी को भी ला सकते हैं। और तो वो एटलीस्ट पॉक्सो के अंदर ये एक इसका फायदा उठाया जा सकता है। तो वो एक बात हुई। सेकंड, ट्रेनिंग पे आपने एकदम ठीक बात कही कि ट्रेनिंग बहुत ही कम है। मैंने जुडिशियल एकेडमीज में काम किया है, कहीं कहीं काम किया है, तो वो मैं कह सकती हूँ कि एटलीस्ट कुछ एफर्ट है। अभी भी बहुत कम है बट कुछ एफर्ट है। जुडिशियल एकेडमीज में, पुलिस में बहुत ही कम एफर्ट है। और जो फ्रंटलाइन आपके जो फ्रंटलाइन ऑफिशियल्स हैं वो तो पुलिस ही हैं। तो इस सिस्टम में जैसे पुलिस है, उनके पास ही आप जाके रिपोर्ट करेंगे तब पूरा सिस्टम ट्रिगर होता है। तो अगर पुलिस में को ठीक से ट्रेनिंग नहीं दिया गया तो ये सिस्टम ही कोलैप्स कर जाएगा, जो हो रहा है। तीसरा, फीस के बारे में सही बात। अगेन, अगर फीस आप ठीक रखे नहीं, पॉक्सो के रूल्स में लिखा हुआ है कि हर स्टेट अपना फीस डिसाइड करेगा, लेकिन मिनिमम वेजेस से ऊपर होना है। लेकिन वो भी फिर भी इतना कम है कि उनका जो आप करप्शन की बात कह रहे हैं, वो करप्शन की आने का चांस है। जनरल आपका इंडियन पिनल कोड में आपके प्रोविजंस हैं। अगर आप इस तरह के काम करते हैं तो उसमें आप पब्लिक जस्टिस, ऑफेंसेस अगेंस्ट पब्लिक जस्टिस के प्रोविजंस हैं, जहां आप अगर झूठी गवाही देते हैं और उस तरह के प्रोविजंस हैं, उसमें आपको पनिशमेंट मिलेगी। लेकिन बात यह है कि लोगों को पता कैसे चलेगा कि आपने बीच में कुछ किया है गड़बड़ी। इसीलिए वीडियोग्राफी का जो एक सिस्टम है, दैट इज वेरी इंपॉर्टेंट। तो यहाँ पे ये पॉक्सो में नहीं है, ये क्रिमिनल लॉ अमेंडमेंट एक्ट में है, विच सेज कि अगर इफ इट्स अ पर्सन विद डिसेबिलिटीज तो मैंडेटरी वीडियो रिकॉर्डिंग है। और वो उसको इंसिस्ट करना इज वेरी इंपॉर्टेंट, क्योंकि बोथ आपके एक तो वर्बल नॉन वर्बल क्यूज दोनों रिकॉर्ड हो जाएंगे। और दूसरा है कि अगर बीच में लगता है कि जो इंटरप्रेटर है या स्पेशल एजुकेटर है, ये कुछ करप्ट एक्टिविटी कर रहे हैं, तो एटलीस्ट उसका एक वीडियोग्राफी एविडेंस होगा जो बाद में चैलेंज किया जा सकता है। तो उस पे इंसिस्ट करना, अगर जजेस को या पुलिस वालों को पता नहीं हो तब भी इसका इंसिस्ट करना, आई थिंक ये एक इम्पोर्टेंट प्रोटेक्शन है, जिसका हम लोग उतना यूज करते नहीं है, पर उसका यूज करना चाहिए। मैं वैसे एक फाइनल बात कहना चाहती हूँ। 2 हफ्ते पहले या 3 हफ्ते पहले सुप्रीम कोर्ट का एक बहुत ही इंटरेस्टिंग जजमेंट आया है। एक चाइल्ड सेक्सुअल अब्यूज का केस था, चाइल्ड सेक्सुअल अब्यूज नहीं का एक person with it's a woman with disability उसका sexual abuse हुआ था and she was also she belonged to a scheduled caste community. तो उस judgment में there's a very detailed discussion on कि कैसे उसका trial process में the court says कि trial process actually ठीक से हुआ था, कैसे उसका recording हुआ, उसका evidence लिया गया, कैसे judge ने evidence appreciate किया. And again, I can pass on the relevant parts of that judgment to Rising Flame if you want to disseminate that. कि उसमें court क्या कहती है about the rights of persons with disabilities during the trial process. I think that's an important thing to also just disseminate further in terms of information.
It is the judgment that actually references the Human Rights Watch report
Yeah,
on violence against women with
yeah, yeah,
disabilities and
yeah,
how criminal law amendment was
yeah.
impacted. The Human Rights Watch report is a couple of years ago, but
Yeah.
it references
You are
the report.
you are talking about 2018 reports.
Yes, yes, yes.
Okay,
But this,
I have read.
no, no, but this judgment came in April 2021.
Yeah,
It references the Human Rights Watch report of 2018.
yeah.
If I may just add on
Yeah.
to something what the speaker before me said, I'm Ambalika from Guwahati, Srisha Sarathi. So hi Aparna, it's a very good presentation, thank you. I just added on, or wanted to add on to what the gentleman before me asked about, and it's a very serious issue of how interpretation ठीक से नहीं हो पाते हैं courts में because of the disability communication नहीं हो पाते हैं, and sign language interpreters का कभी-कभी कमी रहता है, we don't find trained interpreters. But here the most important issue is not everybody with disability requires an interpreter. There are people with different kind of disabilities, could be developmental disability, because of which they cannot speak, because of which they cannot effectively communicate, and these are people who do not require sign language interpreters. So here I just wanted to share how our organization goes about it. So for Assam, basically, people generally, at least in lower Assam, where Guwahati is based, where we are based, people, when I say people, I mean basically courts and the police of the various districts, they know that we are operating here and that we work with children with developmental disabilities. That is basically so-called mental retardation, which we now call intellectual disability. We work a lot, very extensively, with children with cerebral palsy. So these are the two main categories of children who have issues of communication because they do not have speech. They may not have speech. So this is one category. And then we also have a government school in Guwahati, which is for the hearing impaired. Now, very often police do mix up when they issue summons to us and say that, there's a such and such case before us or before the magistrate where we require your expert help in interpreting. And sometimes we get called in a case where they require sign language interpreter, and we said, no, you call school in this case. But in many cases where they have called us, what has happened is our teachers extensively trained on how to do non-verbal communication with the children. So they are extensively using, flashcards and other, what do you call, visual communication aids of pictures and, all those things with the children. So what we do is, when suppose there's a court hearing on Monday, our team of counselor and special educator who is working regularly with children with these flashcards and communication visual aids, they go a day before to meet the person in the presence of the police as well as one of the guardian, usually the mother, because they will not be comfortable with a stranger suddenly popping up in front of them and asking them, things to visual aids, which might be scary. And so they do have a 1 hour, 2 hour session. The person, the girl with disability or the woman with disability becomes comfortable with them, and then next day when they appear before the magistrate and they use the same flashcards. So we have been able to get people convicted in these kind of cases where this flashcards non-verbal communications has helped us in communicating with the victim, in helping the trial process being conducted. And here essentially it's a lot about non-verbal cues and how to go about it. But it's understandable that this kind of expert help may not be available in every district. So this would be a challenge for most of the court systems to work with. So just wanted to share that.
Thank you for
Thank you.
sharing, Amvalika. And I think that the last point you made is also very pertinent, that we might not have that kind of support um, in every state. I think even in the capital cities, I'm not sure we have the necessary support in place, or for the courts to know that this support exists, right, to tap into the support system, right? So thank you, Amalika, for sharing your experience of navigating. There are two questions in the chat box. We'll just close with these two, Aparna. Are there provisions for relief and compensation when the accused is the only earning member of the family? If the child and family are reluctant about reporting the accused, if they are the breadwinner, are there provisions to address that?
See, there is so there are two kinds of monetary reliefs that are provided. One is provided by the state, and the other is provided from fines that are recovered from the accused. Now, for the for either of the systems to be triggered, you have to file a complaint. You have to file a FIR basically under POCSO. Unless an FIR is filed, then there's no scope for compensation at all under this system. And like I said, there's a mandatory for POCSO. There's a mandatory reporting requirement. So anyone you go to, and you report that there has been a sexual abuse and you're requiring some assistance, that person has to report it to the police. So there is no escape there. So anyone you tell that anyone you report to will have to inform the police. So this is part of the legal process, but the compensation from the state is not tied to actual conviction. So the state has these victim compensation funds, and there they are supposed to compensate the victim. So the CWC can make a recommendation, the special court can make a recommendation to the District Legal Services Authority, which is in charge of dispersing these amounts, and that can happen both in the interim process. There's interim compensation that is permissible and a final compensation that is permissible, and it is not tied to actual conviction of the accused person. If the accused person is convicted, then there is a question of fine that comes in separately and over and above the compensation from the state. So the compensation from the state is on the basis of an understanding that the state is supposed to protect our life and liberty. And by failing in its duty to protect my life and liberty, the state should be compensating me for the harm that I have undergone. And separately, the fine from the individual is on the basis that you have committed a wrong against me, and therefore you have to compensate me, right? So that compensation amount is still available. The fine is available only when the person is found to be guilty.
I have one question. So this is in regard to police custody, and also that how many times it has been often recorded that police to put minors under like the age above 18, they record them above 18, and that's how they keep them in custody, and they are not given under the juvenile courts, right? And this has been like especially for the ones that they found them on train or violating smaller laws. Uh, and then there have been reported in terms of sexual harassment cases towards like sexual harassment of the minors in jail, but who are under trials at the age of 18, or like recorded their ages recorded at the age of 18, and there's nobody for them to talk about that what their age is and to correct the police. And this is a very knowing offense that police does on a regular basis. So how do we go about such cases? Because we're talking about this is a very huge chunk of the cases that we'll end up seeing, and the boys and as in the children will be majorly from marginalized communities, and over the years that as we've seen that there is an increase in police violence towards the marginalized communities, and especially like with cases like these. So how do we go about uh, from this angle, because we can't approach, there's just no approaching the magistrate also. So it's a, yeah.
Right. So just to say that's the juvenile justice system intersects with POCSO, but it's slightly different, right? So the Juvenile Justice Act, you have two categories of children: children in need of care and protection, and children in conflict with the law. And the interface with I mean, POCSO can be in both ways, but generally what we were discussing was about children in need of children who've been sexually abused, needing care and protection, and therefore interfacing with the juvenile justice system. But you're right, the accused under the POCSO could be a person under the age of 18. In that sense, might also interface with the Juvenile Justice Act as a person, as a child in conflict with the law. There are, under the Juvenile Justice Act as well as under POCSO, this question of age becomes relevant. So that's something that the magistrate, at at some point where you have to interface with the legal system, that system has to determine your age, right? There are sort of detailed rules on what kind of evidence do you look for. One thing that has happened, that both the Juvenile Justice Act has and courts have also interpreted to say that, at any stage of the proceeding, if you can show that you were under the age of 18, and then that can be at any stage whatsoever, not just at the preliminary stage, but at the stage of final appeal in the Supreme Court, or even subsequently, there have been cases where people have been given the death penalty. It's gone all the way to the precedent to come back to the Supreme Court. At that stage, the Supreme Court has been asked to look at whether the person was a juvenile or not, and the court has said that, okay, that's a question that has to be looked at, right? And if at that stage it is found that the person was a juvenile, even then the entire proceeding can be vitiated. So for what it is worth, that process is there. Again, as we know with any law, any discussion of law in the context of India, we have to realize that the law in books and the law on the ground, there's a bit of there's a huge difference. But the law itself, both under POCSO and so in POCSO, the question becomes of the child, the age of the child, right? That of whether the child is actually under the age of 18 or over the age of 18, and that's a question that the magistrate has to determine. If there's a dispute, the magistrate will have to determine. The general principles of evidence law will apply. If the and so tests that include your looking at your documentary evidence that you might have, or looking at bone ossification tests and things like that. Similarly, under the Juvenile Justice Act as well. But so the police might do whatever it decides to record. The moment the person interfaces with the judicial system is the opportunity to raise the claim of juvenility, or in this case to raise the claim that the person is a child or was a child at the relevant point in time, and therefore should be sent to this system rather than the general criminal law system. Yeah, but to the extent that it doesn't come up before the magistrate at all and it's all happening off the books, of course, we know the kind of police atrocities that happens outside the framework of the outside the purview of the law, and there's very little recourse to that, to the legal system for that.
Thank you, Margaret. And just like the last question from my end. So even when we have said that, like as you mentioned that there is no age, there is like just a second. Yeah. So there is no age bar that is there, that and there is no consent that is done. So how many so what in terms of the readings also, that how this act is actually used by the parents also, that is
Yes.
the children are going against their wishes and having sexual relations, so that is used to yeah, that is used to actually curb the sexual experiences and also put people behind bars if they do not like the person to be said. But it is not considered when we're talking about child marriages, right?
No,
So this act is
POCSO will override any child marriage law. So even when, so there used to be POCSO says any sexual activity under the age of 18 is prohibited.
yes.
The Indian Penal Code actually had this gap, between 15 to 18. It said that if you're having sex with your wife, regardless of her consent, that's fine. That's not a sexual offense. And the Supreme Court in 2016 said no, that doesn't work. So the current position is that any sexual activity within marriage or outside marriage under the age of 18 is a sexual offense. So
Um,
POCSO would apply even if there is sexual activity within marriage under the age of 18.
Right, but the Supreme Court has not taken into the consideration that if uh, the people from the age of 16 or 18 or 15 or 18 will be having sexual intercourse which are consensual intercourses, and how this act is actually used by the parents to curb this. So this aspect is missing,
Yeah,
right?
absolutely, absolutely. You're absolutely right. There's a lot of evidence to say that the law is being used by parents to curb the sexual autonomy of their children, particularly when the sexual autonomy is used in transgressive ways, right? So one is just exercising autonomy, particularly if you're a woman. Second is if it's across caste lines, religion lines, or gender lines, or with not across gender lines, if it's a same-sex relationship, is where you're seeing this used to be the case earlier with kidnapping laws and with general rape laws under the Indian Penal Code, and now it's moved to POCSO. And one of the reasons why it is moved to POCSO is because POCSO is actually a very draconian law, right? You've said you can get up to the death penalty, and the punishments are very high. There's a complete reversal of burden of proof, and so there is a that gives a lot of power in the hands of the police and in the hands of the parents to police the to sexual activities of people who are in that age group, right? 16 to 20, where you could have a fudging of lines, or whether lines are not clear, of age lines are not very clear. So absolutely, you're absolutely right, and that's one of the reasons why there's so much concern about POCSO and how it is being used. In fact, we've found in other studies, people have told us how in different parts of the country, the police actually use POCSO like they used to use NDPS earlier, the drug laws earlier, where it is very easy to catch someone by planting drugs in them, on them. And now, POCSO is another law where basically you have to say that I'm prosecuting you under POCSO, and there's a whole process that kicks in, and you literally have very few defenses left. And so that really empowers the police in a way that we should be very concerned about. So definitely there's a lot of concern about POCSO. It's trying to do good things, but perhaps just in terms of the kind of punishments that it has, and this reversal of burden of proof, etc., is something that we need to seriously think about, because it empowers the police more than anyone else.
And will it also cover transgender
Yeah,
children?
yeah. It says person. It uses gender neutral language. So it says person, any person under the age of 18.
Thank you.
So sorry to everybody else who has asked. There is one question about reporting as an adult,
Hmm.
which I think is a complicated, long answer. But unless Aparna, you have a um,
No, you can. There's no limitation on reporting. So okay, so here's the thing. This law comes into force on the 14th of November, 2012. So any abuse that happened before 14th of November 2012 will not be covered by this law. But any abuse that happened after 14th of November 2012 can be reported at any time. There's no limitation as such. So as long as at the relevant point in time the person who was abused was a child, the person can the offense can be reported, even if the person is now an adult.
Thank you so much, Aparna. This was really helpful, and I think protection of children against sexual offenses is extremely comprehensive, and it's one of those laws that puts many of us who want to talk to children about sexuality, body integrity, consent on the back foot because
Yeah.
of what all the law encompasses. So having the information and the knowledge to be able to take forward ways to protect children by also building their understanding of violations, etc., is very important. So I think all the people who joined today are extremely happy that we could learn about this, and I think grateful for all the people who asked questions, because that always takes the conversation forward.
Thank you.
And
Thanks a lot for having
thank
me.
you, Neha and Atul, for your a fantastic interpretation and making this workshop accessible for everybody. Yeah. Thank you.
My Rights, My Safety, a workshop series on people with disabilities and the law by Rising Flame. Below this are Rising Flame's website and social media links. Website risingflame.org, Instagram risingflame_now, Twitter risingflame now, Facebook risingflame now.